Many around the world believe that there needs to be an international criminal court. But what does the International Criminal Court actually do? Does it really fairly implement law, or is it a political body with a political agenda that prejudices its decisions with terror-supporting states participating? Does this tribunal conduct trials that really uphold justice, ignoring the political pressure of its member nations? Is such a tribunal even capable of serving justice? Ideally, the International Criminal Court should pursue justice and fulfill its envisioned mandate, the central institution for dealing with war crimes and for deterring tyrants from violence.
Good afternoon. The final panel discussion towards a new law of war is devoted to the International Criminal Court. When I studied international law in the Hebrew University, my lecturer told us the first sentence that he actually said was that international law is more international than law. And I still remember that. The questions here have enormous implications for Israel and the world at large. What should the jurisdiction of a court like this be? Can such a court carry out its mandate fairly, given today's fractured political conditions? And I don't mean the fractured political conditions here in Israel. How can such a court be designed so it is truly a court and not a political entity with a specific agenda? And many other questions. Our distinguished panel includes Professor Amichai Cohen, Dean of the Faculty of Law at Ono Academic College, Professor Jeffrey Korn of South Texas College of Law, Professor Eugene Kontorovich of Northwestern University School of Law, and Israel's Cabinet Secretary Avichai Mendelblit. Welcome all, and we'll start with a 10 minutes presentation to have various perspectives on the topic, and we'll start with Mr. Mendelblit.
Because I'm the only one who's not professor.
Okay.
Thank you, Amit. Okay. At the outset, I would like to congratulate the organizers of this conference for this outstanding event. You managed to bring together a variety of speakers from different backgrounds to discuss extremely important issues. Before turning to the subject of my lecture, you don't hear me, so this was a greeting. Try to talk louder, although this is not the best day for it, until tomorrow. Before turning to the subject of my lecture, I would like to refer to the title of the conference, very briefly. In my opinion, humble opinion, the existing laws of armed conflict provide a state which fight terror organization under the armed conflict paradigm the powers and means it needs in order to defeat its adversary. The legal difficulties such a state is facing lie mainly with the efforts to distort the laws of armed conflicts. Okay, thank you. I turn to this point again because I think it's a bit important. I do think that the existing laws of armed conflict provide a state which fight terror under the armed conflict paradigm, the powers and means it needs in order to defeat its adversary. Still, the legal difficulties such a state is facing lie mainly with the efforts to distort the laws of armed conflict by restrictive and unrealistic interpretation, as well as by the efforts to change these laws via an overriding implementation of the human rights law. These are the main problems and the two efforts on which we should focus our attention. Now, turning to the issue of the ICC. The starting point of every discussion about Israel and the ICC should be that Israel, as a law-abiding state, fully supports the notion of international criminal justice for those who are involved in international crimes in case their own state doesn't fulfill its legal duties to investigate and prosecute them. Hence, Israel actively participated in the negotiations leading to the adoption of the Rome Statute. Nevertheless, Israel's concern regarding the ICC itself had begun already upon the adoption of its statute. On July 17, 1998, soon after 120 states voted for the adoption of the Rome Statutes, the Israeli representative to the conference, Judge Eli Natan, explained that Israeli vote will be against it. He said that Israel had never imagined that the International Criminal Court would ultimately become a potential tool in the Middle East conflict. And I would say a potential political tool in the Middle East conflict. And this is the problem. 17 years later, as we see what we are facing now, Judge Natan's prediction seems truer than ever. And this is the problem. It is crystal clear that the Palestinian decision to join the Rome Statute is not driven by the noble values it meant to promote. The Palestinian Authority doesn't seem to care about the international suppression of impunity for war crimes. Indeed, its leaders established a unity government with Hamas, a terror organization committed to the destruction of the State of Israel, an organization which conducts its armed activities in a manner that contradicts every provision of the laws of armed conflicts. The Palestinian Authority glorifies terrorists who are also war criminals and finances their families. The only motive behind the Palestinian signing the Rome Statute is a political one, to increase the international pressure on Israel and to obtain judgment that will give the Palestinian Authority political gains. This is the goal. This is a clear illustration of what lawfare is all about. And here I'm referring to the last definition out of 3, proposed by my friend, Major General Charlie Dunlop, the former Deputy JAG of the United States Air Force. And I quote, "The strategy of using or misusing law as a substitute for traditional military means to achieve a war-fighting objective." This is what lawfare is all about. Palestinian strategy of using the ICC as a tool in their political struggle against Israel is a cynical abuse of a legitimate institution for purposes which are alien to its raison d'etre. Everyone who truly cares about the future of the ICCs, individuals and states alike, should thus stand against this Palestinian move. It is important to know that the Palestinian ICC campaign is only the last phase in a long process, which I call the process of lawfare. And it has 3 parts, turning from political bodies into mixed bodies, political legal bodies, and then to the legal bodies. The first phase of this process takes place in the political bodies of international organizations, such as the General Assembly of the United Nations or the Human Rights Council. These bodies are not authorized to make decisions that are binding to state. Nevertheless, alongside the possibility of recruiting them to condemn the actions of a state fighting terrorism, as has occurred many times with regard to Israel, they serve as a platform to drive processes towards an international legal bodies with binding legal authority, such as the ICC. To that end, mixed bodies, political and legal bodies, are established by the political bodies. For example, various investigatory committees and special rapporteurs mandated to examine the conduct of a state. The findings and conclusions of these committees, mixed committees, are meant to serve as the basis for initiating legal steps in international courts, such as the ACC, and local courts exercising universal jurisdictions. The possible manipulation of this process can clearly be seen in the examination of the lawfare waged against Israel during operation or as a result of Operation Cast-Lead. During the operation, the Human Rights Council, a political body, passed a biased resolution condemning the State of Israel for its actions, which according to this resolution constituted a violation of the laws of armed conflict and human rights law. The resolution called for the establishment of an international fact-finding mission, the Goldstone Commission, a mixed political legal body. The committee's conclusions against the State of Israel were that the Goldstone report determined that the State of Israel committed war crimes because of its international policy of arming the civilian population in the Gaza Strip and punishing the civilian population for its support of Hamas. The report further determined that the legal system in Israel was not interested or capable of effectively and reliably investigating war crimes committed during this operation. And therefore, the committee recommended that legal steps will be taken against both in international criminal court and in local court all over the world with universal jurisdiction statutes. In other words, in legal bodies. So it's what formed from political body, the Human Rights Council, to a mixed body, political, legal body, and to the legal body of the ICC as the final stage. In this end, because of a series of steps taken by the State of Israel in the framework of what I call defensive lawfare, or what might be called counter lawfare, the Goldstone report recommendations were not adopted. This type of process was also taken against Israel with regard to the events surrounding the takeover of the Turkish flotilla in May 2010, and a similar process is currently taking place with regard to Operation Protective Edge after the Human Rights Council adopted a unilateral resolution condemning Israel and ordering the establishment of an international commission of inquiry. In this last case, there are clear indications that the establishment of the commission was specially designed to establish legal procedures against Israel. First, William Schabas, who was chosen to head the commission, as previously said that the Prime Minister of Israel needed to stand trial in the ICC. Recently, Schabas had to resign after it was revealed that several years ago he did advisory work for the Palestinian Authority regarding their efforts to join the ICC. In addition, the Commission's mandate states that it must determine which individuals are responsible for the war crimes committed by the State of Israel during Operation Protective Edge. Finally, this Commission mandate refers to the events which took place from June 13, the day after 3 Israeli teenagers were kidnapped and murdered in Gush Etzion. This is also the date that appears on the Palestinians' current attempt to accept ICC jurisdiction pursuant to Article 12.3 of the Rome Statute. Palestinians' lawfare campaign against Israel following Operation Protective Edge is meant to seriously undermine Israel's international standing and places it in an equal footing with pariah states that regularly violate international law, like Sudan, Milosevic and Serbia, South Africa of the apartheid, and so on. This step has far-reaching political and economical implications. By taking these actions, the Palestinian Authority intends to put international pressure on Israel that will, at the end of the day, advance its political interests vis-à-vis the Israeli-Palestinian conflict instead of the track accepted by the international community, that of bilateral negotiations. Naturally, at this stage, I am not able to expand about Israel's reaction to the Palestinians' lawfare efforts, and let me show that there are steps taken by the State of Israel, and in particular, its ICC campaign. Nevertheless, and that would be my concluding remark, meanwhile, I can assure you that the State of Israel is doing its utmost in order to make sure that no soldier or commander will be subject to legal proceedings abroad, either in the ICC or in any other state under the principle of universal jurisdiction. Thank you.
Thank you, Mr. Mandelblit, and now Professor Eugene Kontorovich, please.
Thank you. So first let me begin by explaining why the Palestinians' invocation of the authority of the International Criminal Court is objectionable from a legal perspective, and then I'll turn to the question of whether Israel can expect fair treatment from the International Court. So when you first hear it, you'd think, what could be wrong about joining an International Criminal Court? Isn't that nice? More international law, more support for holding perpetrators of serious crimes responsible? What could be wrong? So the first thing to understand is the International Criminal Court is not some Olympian tribunal that is in regular session reviewing the rights and wrongs of conduct by forces around the world. Indeed, thus far, it has only finished 3 cases, and as a special treaty organization, it can only exercise jurisdiction when countries specifically consent under very limited circumstances. The United States is a big supporter of this doctrine, as the United States itself is not a state party. Israel also is not a state party. The Palestinian turn to the International Criminal Court is illegal on 2 fronts. It's illegal because it doesn't work under the Rome Statute. The Rome Statute is limited in its membership to states. Palestinian Authority is not a state. We'll discuss this in a second. Also, even if a state can be a member, jurisdiction only extends to conduct on the territory of that state. To the extent that the Palestinians are seeking to assert jurisdiction over Israeli civilian communities in the areas of Israeli jurisdiction under the Oslo Agreements, that would be another violation of the Oslo Accords. It's all of the Rome Statute. It is also a double violation of the Oslo Accords, because under the Oslo Accords, the Palestinians pledged to not seek a final status determination outside of negotiations. Here they're seeking to determine both statehood, final status, and precise borders outside of negotiations. Also under Oslo, the Palestinians agree that Israel shall exercise sole criminal jurisdiction over all Israelis in Judea and Samaria. Now the Palestinians are trying to delegate to the ICC what they already agreed Israel would have, trying to sell the same horse twice and violating the Oslo Accords. Okay, but still, what's the big deal? If Israel hasn't committed any crimes, what's there to be afraid of? Why worry? So there's a few reasons. One reason is built into the Rome Statute itself. The definition of the crime that people popularly refer to as settlement was put into the Rome Statute specifically targeted at Israel, and it's the only such definition. Every other definition is just borrowed from pre-existing war crimes definitions in international treaties. There was a concern by some states that the definitions regarding settlements might not actually make Israeli settlements illegal. That would be too bad. And so they inserted words into the text which they thought would increase the likelihood of that legal conclusion. The only provisions put into the Rome Statute to target a particular country, they were introduced by a group of 6 Arab states, including, amusingly, Morocco, which I think is further proof that it was understood that this is for one purpose only, to target Israel, because Morocco did not stop its settlement enterprise in West Sahara upon suggesting this expanded definition. So there's a bias against Israel built in. Right? Israel would be judged by a law made specifically for it and not applied anywhere else in the world. By the way, how do we know that this law is made only to apply to Israel? That that's actually the legislative intent? Because Cyprus has been a member of the Rome Statute since the creation of the International Criminal Court in 2002. But the prosecutor has never even thought to move to open an investigation into the large-scale Turkish settlements in northern Cyprus, where the Turkish settlers are now a majority, despite having had continuous jurisdiction over this major demographic change since 2002. Arguably, the prosecutor is acting in fidelity to the real intent of these provisions of the Rome Statute, which are not to stop Turkish settlements, but which are to get Israel. Then one can look at the actual conduct of the prosecutor so far. The prosecutor has made 2 legal proclamations relevant to Israel. Both have been wrong, and both are also mutually contradictory, which is neat. Usually if 2 things are wrong, they're not necessarily mutually contradictory. These are both cancel each other out and are wrong independently. First of all, the prosecutor concluded that Gaza is occupied. The prosecutor didn't have to say this. She found that the relevant situation involving the Maria Marvara, ships registered to the Comoros, was not one over which the court had jurisdiction, but nonetheless she went out of her way to say that Gaza is occupied. Now let's review some definitions of what occupation means under international law. According to the ICJ, the International Court of Justice, occupation is territory that is actually placed under the control of the hostile army. The court said this in a case, Congo versus Uganda, in which it found that territory controlled by an allied militia with the support of a hostile army is not actually occupied. You would thus think that territory controlled by a hostile militia, such as Gaza, would a fortiori not be occupied. Consider the ICTY definition. The occupying power has established an administration over the territory. Or consider the definition of the International Committee for the Red Cross. Occupation, they put this in big bold letters in the manual they use for training of commanders. Occupation ceases when the occupying forces evacuate the territory. No footnote, no exception, clear take-home rule. The prosecutor did not engage any of those definitions, didn't even mention them, because she had a different source of legal authority. She said Gaza is occupied, and again, occupation is a legal term. Right? It's a term of international law with definitions, and you have to figure out, do they apply? Prosecutor did not engage in that. She said, the General Assembly said it's occupied, so who am I to argue? Okay, so that's how Gaza comes to be occupied. The General Assembly says so, in clear violation of the definitions of the ICTY, the ICJ, and the ICRC, but who cares about them anyway? The next, a few months later, the prosecutor comes out with a different statement. Palestine, which was not a state when we checked a few years ago, has become a state. That's quite amazing because, again, statehood is not an emotional concept. It's not a reward for people who've suffered. It's a term with an international legal definition. To become a state, it requires to have control over territory. To be occupied means you don't have control over the territory. So having found that the Palestinians don't have control even of Gaza, where their control is the greatest, it's amazing that the prosecutor then finds that they had enough control to become a state, which is a great level of control. So how can it be a state? They're not a member of the United Nations. They don't seem to exercise effective control, according to the prosecutor. She doesn't, again, engage in the legal definitions of statehood. She just says they're a state because the General Assembly has said that they're a state. So this is a very alarming development. First of all, there's no requirement of logical consistency. Secondly, according to the statute of the ICC, and the entire political idea behind its creation, is it's supposed to be independent of international politics. The General Assembly, of course, is the apotheosis of international politics. That's why no one allowed the General Assembly to have a court or any other powers. If the prosecutor takes General Assembly pronouncements as binding statements of international principle, she forfeits her independence, she forfeits the court's independence, and also the court's claim to be applying legal standards. It's okay for the General Assembly to say Gaza is occupied and Palestine has become a state. They're politicians. They don't have to be consistent. But that's not international law. Okay, so there's a lot to worry about. That is to say, there's a final beautiful detail. Recently, the prosecutor has clarified her statement that Palestine has become a state. She has suggested that Palestine is a state for purposes of the ICC jurisdiction only, suggesting that the Rome Statute's definition, word state, again, an international legal term, has a meaning in the Rome Statute that it does not have anywhere else. Naturally, Israel finds it troubling that words can have meanings that are unique in situations involving it, because you can try to comply with international law, you can do your best, but if words can take unique, sui generis meaning for the Rome Statute only, who knows what's going on? So that is very troubling. Okay, now something has happened. I want to relate to the ICC proceedings have massive implications, not just for Israel, which the cabinet secretary mentioned. They have massive implications for other countries. The rules that the jurisdiction the Palestinians are seeking to exercise will require the court to adopt definitions of complementarity and gravity that are so low and so thin that US, British, and other Western forces who are already under preliminary examination would certainly face significant legal challenges as a result of these precedents being established. If the ICC proceeds, for example, with an inquiry into Israeli civilian communities in Judea and Samaria, in Area C, it will have massive implications for the European Union, because presumably the ICC would then have to open up an investigation into the Turkish settlements in northern Cyprus, and also Russian settlements in Georgia, which is a matter under investigation. And indeed, if the Ukraine joins, the ICC can spend the next 10 years doing nothing but investigating settlements in Crimea. This, of course, assumes that the rules that are applied here will be applied elsewhere, which is not an assumption that has necessarily been proved. I need to finally mention, in my last minute, the relevance of Shurat HaDin for this matter. And it's in an inadvertent relevance. When Shurat HaDin brought the Sokolov case about Palestinian funding of terror in US District Court 10 years ago, no one thought it would be relevant to the ICC because no one was thinking about the ICC. The case drags on for 10 years, and just a few months ago, a United States court rules that Palestinian ex post payments to terrorists are a form of direct commission of terrorism. A form of direct commission of terrorism. That is extremely relevant for the ICC because much of this discussion has so far said this is a great move for a boss, because if the ICC investigates anyone, it would have to be Hamas for rocket fire. But now you have a US District Court, a very serious court, has made a serious ruling which the ICC cannot ignore, that ex post payments are actually ex ante solicitation, and now if an investigation does not include a boss, whose programs and ex-post funding for terrorism are actually much more generous, formal, and expansive than what existed 10 years ago. They look much worse because payments are now proportioned for length of sentence, which is proportioned to degree of severity of the crime. Now the ICC has to go after a boss. They can't just bethrone a couple of Hamas rocket squad leaders. Finally, a word about this important legal theory that has been established in US District Court. The Palestinians argue, and they will argue in the ICC, you can't say that we got people to commit terrorism by paying them once they committed the terrorism. You can't, it doesn't work that way, right? If you only pay them after, that doesn't affect their incentives ex ante, it doesn't affect anyone else's incentives. At the same time, they're going to make another argument. They're going to say Israel has moved people to the settlements. How has it moved people? I didn't see any trucks, buses. They moved people by having the people know that if they move there, they can turn the power on. And that if there's security problems, the army will provide security, and they won't cut off the power, and they won't close the roads, and they won't mine the bridges. In other words, the ex-post provision of minor municipal services actually gets people to move to places. If that's true, certainly, which I don't think it is, certainly it's true that the ex-post payment of money gets people to kill other people.
Thank you, Professor Kantorovich, and now Professor Amichai Cohen.
Thank you very much, and thank you for the organizers of this impressive conference and for the audience for coming here and listening. Everyone who's followed the news in Israel closely knows that there are ongoing investigations and inquiries by the Military Advocate General of the IDF regarding the events of the recent operation. Now, some claim that these justification for these investigations or inquiries is somehow to block or halt international investigations or some kind of international tribunal intervening and prosecuting Israeli soldiers. I do not agree with this claim in the following sense. It cannot be a reason for investigating in order to halt international investigation. The reason for investigation is that we want to know and to assure ourselves and the public that indeed the IDF has acted correctly. However, if we already undertook these investigations, it might be an interesting fact to know whether indeed one result of the investigations is indeed to halt or avoid these international interventions or prosecutions of IDF soldiers. So does it work? I would also make one introductory remark, and it is that there, as Professor Kantorovich said, there are other reasons why international tribunals or body will not intervene in what happened in Israel. It might be because there is no state party that is complaining if the Palestinians are not a state, or it might be because the gravity of the crime is not, the crimes are not grave enough, as happened in the flotilla incident. So there are other reasons. But one reason, one obstacle for international intervention is the principle of complementarity. The principle of complementarity, in short, and declares that a court, an international court, is barred from exercising its jurisdiction when a national court or investigative authority asserts its jurisdiction regarding the specific case. So this is one definition I took from the late Antonio Cassese. So complementarity means that if domestic investigations happen, then international tribunals, international bodies, including, of course, the ICC, will not intervene. What are the reasons for the principle of complementarity? Three possible reasons have been raised. One is a simple practical reason. It's improbable that an international tribunal will be able to have enough manpower, resources in order to indict all violations of international law in a case. We have seen international tribunals and bodies, they have indicted, I think in Yugoslavia, this was the court that indicted most, it was less than 200 people. So, and of course, there were more than 200 criminals in the wars in Yugoslavia in the 1990s. So one reason is practical. Of course, practicality is not a good explanation for the principle of complementarity because it doesn't explain why the court is barred from indicting. It might say that the court might choose not to indict anyone, but why is it barred? So two other explanations. One explanation is, I would say, a political explanation, declaring that there is some kind of division of work between national and international authorities. So the national authority is supposed to investigate. The national authority is the correct way of investigating. And international law, international bodies should respect this primacy of the national system. It's only when the national system does not investigate, is unable to investigate, is collapsing, in a sense, is not independent, etc. In these failed incidents, then an international tribunal should replace the national system. But there is also another explanation for the principle of complementarity, and it's that it's simply a matter of a competition between jurisdictions that you have to have some rule of deciding, meaning assume that there is a person and a national investigative authority is investigating this person in suspicion of violation of some kind of law. And now there is also an international authority that wants to investigate the same person for the same crime. So there is a conflict of jurisdiction. There is a competition between two jurisdictions. And you have to decide one way or another, and the rule of thumb that has been accepted is a primacy of the national system. But it's not because of principled respect to the independence and sovereignty of the state. It's just that we have to have some kind of rule, and this is the rule that has been accepted for perhaps political reasons or some other reasons, but it's only regarding the competition between states. Now, these two explanations have very different implications. Because if the rule is based on the idea of the primacy of the state, the respect of the state, the international tribunals kick in only if there is a failed state, then you have to prove that the state is not acting, or not acting at least in good faith, in order to cause the international courts to intervene. Meaning complementarity would be a very important principle. It would bar international interventions in many cases by the simple fact that there is a state there, and the state has an independent investigative authority, independent courts, that why should the international bodies intervene? However, if you accept the second explanation, or the third explanation actually, of complementarity, meaning it's only a conflict of jurisdictions and you only need to have some kind of rule when you have a competition, then the complementarity principle is much more limited. It only means that if a state has actually started to investigate a specific person for a specific crime, then the international authority will not investigate the same person for the same crime in order to avoid the competition between jurisdictions. So the principle of complementarity is a much lower bar to pass for the international tribunal. So between these two explanations, which one has the International Criminal Court accepted? Now we have already several cases. I will not discuss all of them. There were in two areas in the world where the court has asserted jurisdiction. Now, of course, Professor Kantarovich is right. There are only 3 cases in which the court has finished the discussion, convicted, but there are, I think, 23 cases pending before the court at some stage or another, coming, some of them from Libya and from Kenya. Both of these countries have asserted the principle of complementarity, meaning they want to bar the court from intervening because they claim we want to indict the person. And I think the best known case is the case of Saif al-Islam Gaddafi, where Libya has said, we actually have him and we want to indict him. And the court has said, no. The principle of complementarity, and this is the important point, and this follows the jurisdiction of the court in other cases, the Taru case and other cases in Kenya, the court has said, Ratu, I'm sorry, not Taru, Ratu case in Kenya, the court has said, we're very sorry, the principle of complementarity is a very limited concept. It means that if your investigation is in a very developed stage, where you actually developed a case against Saif al-Islam Gaddafi, then, and it's approximately in the same crimes that we want to investigate against the same person, then the principle of complementarity kicks in and we will not have an investigation. But if you're only developing an investigation, you don't know exactly who and why you want to investigate, and you're not sure about the crimes that the person will be indicted for, this is not enough for us. So my understanding, and here, of course, we have a limited set of cases, only 4, so I stand corrected, but I think it's a pretty, there are other reasons why I think this is where the court is going. The court is going to accept the limited interpretation of complementarity, meaning the conflict of jurisdiction interpretation. The court will not use complementarity as a way to say, listen, this is a good faith state, we believe in this state, and we will let it run the course of investigation. What does this mean? It means, of course, that, and once again, I'm not saying that the ICC is necessarily going to intervene in any case. I don't know. There are other reasons why not. However, if the International Criminal Court will pass the other bars, the bars of having jurisdiction in terms of a state and the question of gravity of the crimes, in order for Israel to use the principle of complementarity, it will not be enough for Israel to show that it has an independent investigation in general, to show that its court system are independent in general. Israel will have to show some kind of inquiry into a specific case in order to halt the jurisdiction of the International Criminal Court in a specific case. If I have 2 more minutes, 2 more minutes or not?
1.5.
What?
1.5.
1.5. I'll explain. I called it, this what I'm presenting here is part of a paper that's called The Paradox of Complementarity. Of course, I think, and here I'll just finish with it perhaps with a hint because I only have 60 seconds left now. So, of course, it's the wrong way to go, I think, to go about complementarity, because what the International Criminal Court is trying to do is not to indict every criminal. The court is trying to convince states to apply international law. If you want to convince a state to apply international law, then all scholarship directs us to saying that you have to legitimize international law, meaning you have to convince domestic groups within the state that international law is a good thing. However, if you force states to indict or investigate, even in cases where the domestic authorities, independent authorities, do not think that they should do it, only because they are afraid of some kind of international intervention, this is the wrong way to go about internalizing or causing states to internalize international law and legitimizing it within a state. But that, once again, with that, I'll end, and thank you very much.
Thank you. And now, Professor Jeffrey Korn, please.
Thank you again for the opportunity, and again to the organizers, and to be among such an amazing group of experts. I want to focus on what I believe is the very genuine danger of the gap between what I call aspiration and reality of international criminal law, especially when we move from the extreme cases of what we might call blatant violations of international law, firing mortars into a marketplace on a Sunday morning with no plausible military justification, or using snipers to shoot at civilians who are trying to get water when all the water has been cut off in Sarajevo. When we move from that domain to the domain of complicated battlefield judgments by military commanders in the chaos and fog of war. I think this is where the real challenge of application is going to arise. So for the past 20 years or so, the international criminal tribunals have been focused primarily on those malum in se type offenses. But when they confronted several cases involving the complexity of the battlefield, then I think some of the dangers of this gap between aspiration and reality started to emerge. So what was the aspiration? I think our first speaker hit the nail on the head. We should not be opposed to the aspiration of an international tribunal that can credibly adjudicate the most egregious breaches of established rules of international law to prevent impunity when states refuse to address those violations through their own systems. The fear is that the reality is quite different, that the reality is that the court becomes an opportunistic interference with good faith accountability efforts by states in an effort to create an imprimatur of credible justice. And part of that imprimatur, ironically, is this assumption that if international criminal justice is going to be credible, we have to rely on civilian jurists and civilian judges to do the adjudication, which creates, in my mind, a real irony, that we're judging the decisions of battlefield commanders on the question of whether they complied with rules of war, and the people that are judging them are not experts in the context in which they're adjudicating. I will admit my view on this was influenced substantially by my role in a case involving a Croatian general named Gotovina, who was accused and convicted of unlawful shelling and attacks of a city in Croatia in 1995 in Operation Storm. And my experience with the tribunal, really, this was the International Criminal Tribunal for Yugoslavia, but I think is kind of consistent with the overall model, left me really discouraged with the way this process played out. By the way, before I get into the specifics of that, I just want to add one comment to your point, Eugene, about the invalidity of the acceptance of the Palestinian request for admission to the ICC. I think another very significant problem with that is that the Rome Statute created a fail-safe mechanism. It created a mechanism whereby a state that is not a party to the treaty can be subject to the jurisdiction of the tribunal, but it required the Security Council's support for that. The Security Council had to decide to refer the case to the ICC. So what the ICC has done is it has essentially usurped the authority of the Security Council to exercise this extraordinary mechanism for bringing cases before the court for states that are not party to the treaty itself, which I think is another aspect of invalidity. But back to this point about the gap between aspiration and reality. I think there's an inherent danger involved in allowing international criminal adjudications of complicated battlefield judgments to be made without an adequate foundation of expertise in the context that they're adjudicating. This relates to some of what I was talking about yesterday. Bad judgments by international criminal tribunals will have automatic shock effect on the development of the law of armed conflict. They will be seen as definitive statements of what the law requires, or as I might say more simply, what right looks like. And if they are attenuated from the reality of the battle space and the reality that the commander confronts in the chaos of war, they will result in tactical hesitation. They will incentivize the abuse of the civilian population by enemies who are trying to seek an advantage by abusing the law. And I think most problematically, they will make commanders start to view the law as non-credible. So their commitment to the law will become much more pro forma than the type of commitment to the law that we heard manifested this morning from the Israeli general who was talking about why the law was so essential to the credibility of Israeli military operations and the morality and the moral integrity of the military. That's the understanding of the law we want to incentivize. We don't want the law to be perceived by the constituent, the military that has to follow the law, as a fig leaf, where all we do is we say the right things, we produce the right documents, but we all really start to see it as irrelevant to the actual conduct of military operations. So I think the credibility of these adjudications is contingent on two fundamental foundations. First, culpability for any commander brought before the court must be assessed based on the situation that confronted the commander at the time of the alleged unlawful decision. We cannot allow effects of an attack to be a substitute for the hard work of establishing proof beyond a reasonable doubt of unreasonable battlefield judgment. And in the case that I was involved in, that's what ultimately led the conviction to be reversed on appeal. Because when Judge Meron looked at it on appeal, his frustration with the trial court's conviction was that it was not based on a recreation of the tactical situation, it was based on the effects. Some of you may be familiar with the infamous 200-meter rule. Anytime a shell falls within 200 meters of the target, it is beyond an acceptable range of error, with no expert foundation for that conclusion whatsoever. So fortunately, the appellate chamber rejected that conclusion, but the trial chamber judgment is a warning that the lack of expertise on military operations is going to risk the tendency to gravitate towards effects-based adjudications, which will put commanders in a terribly unfair dilemma. Second, the reasonableness of those judgments must be assessed based on the totality of the relevant circumstances and a standard of reasonable judgment by a commander. Now, how can a civilian judge who's never been in uniform, who's not advised by an expert on the court, who is an expert in military operations, judge whether or not a military commander's judgment was within the range of reason? This is what Panina was talking about this morning. This is what some of our commentators were talking about this morning when they talked about mistakes that you find out afterwards were reasonable but are going to be condemned because they were in fact mistakes. If we are going to adjudicate complicated battlefield judgments, the standard has to be acknowledged, and that standard has to acknowledge that there is a wide range of discretion, a margin of appreciation, and we have to get comfortable with the reality that in many cases we may look at a situation and say the outcome was not ideal, but it was far from criminal. And my fear is that the tendency is going to be to move in the opposite direction. When the outcome is not ideal, it will ipso facto create an assumption of illegality. And that is inconsistent with the reality of warfare. One of the challenges, I think, for any international tribunal going forward is how do we incorporate military expertise into the adjudication process? And I don't think it can be as ad hoc as it was for General Gotovina. General Gotovina was lucky because the government of Croatia helped fund his defense, which means his defense team had abundant resources to find the experts in the world that could help the tribunal understand the reality of warfare. Not every defendant is going to have that luxury. And they're going to be dependent on the resources that the court is going to provide. And I think those resources for the defense will always be outmatched by the resources of the prosecution. So one very difficult question I think that the international community has not grappled with is why do we assume that a civilian judge is in a better position to judge battlefield misconduct, alleged battlefield misconduct, than a military expert? Why aren't those tribunals composed in a manner that looks much more like the international military tribunals that were conducted after World War II? Why is there an assumption that a military adjudication is somehow inherently invalid? I would suggest it's the exact opposite. That if you want a credible adjudication of whether a commander's judgment in battle was unreasonable, it should be other commanders who are sitting in judgment of that decision. They have the greatest incentive to hold illegal conduct to a high standard, but they also have an incentive to make sure that commanders are not held to a standard that's impossible for future commanders to live with. And the third element of this that is essential, and it goes to the point of complementarity, is we have to recognize that when we're talking about an international criminal adjudication or a criminal adjudication at any tribunal, we are taking a regulatory norm, a law of armed conflict rule that was developed to regulate conduct, and we are transforming it into a criminal accountability norm. When we transform it into a criminal accountability norm, that means that it is subject to the standards of criminal accountability, which means guilt must be predicated on proof beyond a reasonable doubt. Proof beyond a reasonable doubt requires that the evidence rule out every fair and rational hypothesis other than guilt. That means that there will be many cases, particularly when we're talking about battlefield decisions, where the decision might have violated the rule from a regulatory standpoint, but the evidence is insufficient to establish criminal culpability. And why is this related to complementarity? Because when a military advocate conducts an investigation of an alleged illegal attack, there may be, in many cases, a conclusion that things should have been done differently and things could have been done better, but that the evidence is insufficient to justify a conclusion beyond a reasonable doubt that the conduct was illegal, in which case the recommendation would be to look at the procedures, maybe adjust our methods, maybe change our training, but not bring a criminal case. If complementarity moves in the direction that my friend predicts it will move, that will be viewed as insufficient response, and it will invite the intervention of the International Criminal Court, which is highly troubling, because this is the reality of how battlefield misconduct is investigated. And anybody in this room who's been a military judge advocate knows exactly what I'm talking about. There is a huge difference between a regulatory violation and a criminal violation. But I don't think that the discourse on these tribunals has recognized that at this point in time, which is one of the reasons why General Godovina's reversal, the reversal of the conviction in that case for failure of evidence, was met with such opposition in the international criminal law community. Because they, in my view, they could not understand the difference between the standard at a regulatory level and the standard at a criminal level. So acknowledging the consequence of transforming a regulatory norm to a criminal norm has to be central to the credibility of any international criminal adjudication. So if complementarity moves in this direction, the next phase of the battle will be making sure that these adjudications are credible. And if we start with the assumption that any time an individual is brought before an international criminal tribunal, they are presumptively guilty, we have flipped criminal law on its head, and we have fundamentally distorted the aspiration which the tribunal was created to advance. Thank you.
Thank you very much. And after this introduction, I would like to ask you to begin with you, Mr. Mendelblit, and I'll ask you to re-wear your uniform as Major General and take us into the inner rooms in which operational decisions were made involving legal advisors like you, for instance, during the cast-led operation and so forth?
What is the question? What is the question?
To take us into the room and to tell us how exactly decisions are made, maybe fearing from the fact that ICC might take us, I mean, that we will find ourselves in the ICC and so forth.
So, if I may, it relates to it, but I would like to go a bit forward after, and then I go backwards. After I retired, about 3-4 years ago, something like this. It's okay. About 3 years ago, I used to give some lectures. I was asked to deliver lectures, and the places that I went was especially to youth who were very close to recruitment, especially, by the way, religious guys in yeshivot or mechinot, what they call. And I thought it was very important to be there and explaining them. I was asked by the rabbis to go there and explaining them the place of the rule of law in the military, and I think it was very important. Now, I used to start with the saying that in Hebrew it says, "Nam levadad yishkon uvagoim lo yitchashav," which means we are by ourselves, we don't care about the world, and we'll take care of ourselves, something like this. And all the lecture went to a place where this saying is not correct today, because we have to consider, of course, the other nations, we have to consider the ICC, the international courts, and so on. And we went there. I think it's very important, because we live in a world where it's very important to be part of the community of nations and countries who respect the rule of law. It's very important to be part of them for practical reasons. But at the end of the lecture, I came to the place in which I believe, and I think this is the way the IDF works at the end of the day. We do not undermine the importance of the word, of course, and the practical reason, but more than this, this is for ourselves. So 25 slides or something like this was about that we do have to consider what the word says. And at the end of the day, there was one slide that says, forget all of that I've said. The only thing that we should care about is ourselves, because we should be the importance of morality in the IDF. And I say morality, not law, morality, which is something that is more than law. There are things that are allowed by law, especially laws of armed conflicts, and still commanders will take the decision. I've been in these cases, then I'm going backwards. And commanders in the Air Force, in other places, took decisions that are going beyond the law. Things that are allowed by the law, decided not to do it because of more questions. But what I told them that is the most important thing is that we will be able to stand and say and look in the mirror and not be ashamed of ourselves. And that is the reason why I have to go and investigate everything that is suspicious as war crime. And I'm going with what Jeffrey Cohn said. I think this is very important to understand it. We are not in the midst of Tel Aviv or New York City or Washington, D.C. We are in the battle. When a battle, we have to take into consideration all the things that a commander should take into consideration. And decisions are taken in soldiers, not only commanders. And decisions are taken under the midst of war, and they have to take quick decisions, and mistakes are being made, lots of mistakes. And this is the price of being in a combat, and especially in the combat that we are conducting today, asymmetric warfare. The fight is intentionally brought into places where civilians are mixed with the soldiers, or what is more correct to say, unlawful combatants, and we have to take the decision. We have to take this into consideration, all this. Now, What I'm saying, first of all, is the last paragraph, no, it is not because of the Agfir. No decision is because of Agfir. No, there is no way that a soldier or a commander should be tried, not even investigated or brought into a risk, a legal risk, because we have to do something that the world will stand there and applause to us. We are not doing it. Everybody who was under investigation, there was a reason for it. And it's not, you don't count numbers and say, look, there's a lot of criticism in the world, so I have to bring 50 soldiers into trials or 200 soldiers into investigation. There's no way we're going to do it. Because the decision should be taken according to our standards, and we are certain that our standard meets, and we know today, after all what we've done, Technical Commission and so on, that we know that our standard meets the international standards, but we work according to our standards, not because we have to satisfy anyone in the world. Going backwards now, this is the way that the things are there. We have a change that was made during my time as military advocate general, but I think the roots are in my predecessors, Justice Menachem Finkelstein, and Pnina is here. She worked a lot with me on these issues, and Daniel Reisner. So it was developed. And the idea was that we're working together with the commanders. We are there, and we're trying to help them take the correct decision according to the rule of law, which is important not only to us, but to them also. So this is the truth. This is what we believe in, and thank you.
Professor Kontorovich, the United States law authorizes the president to utilize military force to retrieve any United States service member who is held for trial by the ICC, and prohibits any U.S. official from cooperating with or assisting an ICC investigation. And the question is, does Israel need to adopt a similar law?
So, the United States has a law, which is affectionately known. It's actually called the Armed Service Members Protection Act, and is affectionately called the The Hague Act, which does authorize the use. It doesn't authorize the use of force in particular, but the use of any means to rescue Americans held for prosecution by the Hague or by a country which wishes to turn it over to the Hague. It's useful to point out that American law is relevant already to Israel without the need for Israeli law. The U.S. statute also authorizes the suspension of aid to countries who do this, not just to Americans, but to a group that is defined as Americans, NATO allies, and major non-NATO allies, which is a list of countries that includes Japan and does include Israel as a non-NATO ally. Now, the president needs to decide to do that, and that is unlikely to happen. Even for U.S. servicemen, I think. The United States law also provides that a organization that gives the Palestinian Authority the same standing as a member state must have its funding cut off. According to what the ICC prosecutor has said, that the Palestinians have standing at the ICC, not because of any decision she made, but because of a decision made by the General Assembly. One might say that the General Assembly has given the Palestinians the same standing at the ICC as a member state, and thus the UN must lose its funding. Now, that would be important. Israeli laws, obviously, can have a much more limited scope, because Israel is not a major provider of foreign aid, and I think it's extremely unlikely that countries will be in the practice of actually. The point of these, it's important to understand the point of the Palestinian activity. The point is not to have Israeli officials put in handcuffs and taken to the Hague. That is both unlikely. It's unlikely they would actually, the Hague would try to do this, the ICC would try to do this, and they have a very poor success record of going after heads of state, so far 0 for 2. That's not what it's about. It's about international delegitimization. It's about turning a negative spotlight on Israel. So worrying about people going to jail is really not putting the focus on the major thrust of the problem, so such a law would not be particularly helpful. At the same time, I think it's important for Israel to make clear that if it is singled out for a special scrutiny which in its uniqueness is not consistent with international law, it will do everything it can to make sure that the same scrutiny would be focused on other countries. So Israel could be in a position to ensure that if Israeli settlements were subject of an ICC investigation, Turkish settlements in Cyprus would also be something which would be, I think, extremely disruptive, for example, for European politics. That's something that Israel could do that could be potentially useful.
Yeah, just a few points. First off, the provision of the law that authorizes the president to use force to recover an American is completely superfluous. It's an established principle of American constitutional law that if the president believes an American needs to be rescued from abroad, he has inherent authority to do that. And Congress cannot dictate that he do that because it's an exercise of executive discretion. So if the president felt that an American service member was unlawfully detained and needed to rescue him, he could do it without the statute. And if there's a statute that says he can do it and he doesn't think it should be done, it's not going to happen. So it's hyperbole. The much more significant aspect of that law has to do with the fact that the United States has an expeditionary military. Our forces are stationed all over the world. And Article 98 of the Rome Statute required member states to cooperate with the prosecutor. That created a real dilemma for U.S. forces because in the event that American servicemen who happens to be stationed in Germany or Italy or Japan becomes the subject of an ICC indictment, then that state has an obligation to support the ICC prosecutor. So the United States was using this to send a marker to all of the countries that we cooperate with that if you prioritize your interest under Article 98 over the interest in our relationship, there's going to be a serious price to pay. And I was personally involved in some of the negotiations when the U.S. Army in Europe would negotiate training rotations to Poland or Hungary or the Czech Republic because we had to establish an agreement that said they would agree not to enforce that Article 98 provision if our forces were there training. So I think the expeditionary nature of the U.S. military creates a very different situation. Having said that, right, and again, my experience with General Gotovina, I don't think the nation of Croatia was excited about the fact that General Gotovina was on trial. Their only remedy was to do the best they could to give him the best defense he could have. This is a real risk. And it's a risk that military forces who are in a country that legitimately and credibly investigates misconduct of its armed forces, that prosecutes cases where it's appropriate, should have to worry about when they go on holiday in Europe or in England or in the Far East, that there's a secret indictment somewhere that they don't know about. This is unacceptable, but it really comes back to the complementarity issue, which has to be the first line of defense against this.
Professor Cohen, is there any structural change to the court which you could recommend that would that could actually make the Americans adopt the ICC or join the ICC as we know it? But it's for both of you.
Yeah, so look, the United States was, like Israel, was not opposed to the concept of the ICC. And as a matter of fact, we were a major advocate for a permanent international criminal court. We helped create the ad hoc tribunals for Yugoslavia and Rwanda, but the problem was they had no jurisdiction over conflicts in other locations. So the theory was we need a standing court to respond to cases of genuine impunity. The big concern that led the United States to ultimately decide not to join the tribunal was the independence of the prosecutor. The United States wanted the Security Council to have a check on the prosecutor's discretion. The rest of the member states said no, the prosecutor has to be independent. The United States said we're concerned that independence will be abused and will result in political manipulation. So what has happened since then? Ironically, the issue that you all worry about, the issue of Palestinian admittance to the court and the ICC prosecutor opening case investigations against the IDF, is the worst thing the court could do if it ever wants the United States to join the tribunal, because that is confirming the fear that the United States had from inception, that the prosecutor cannot act credibly and that the prosecutor is not going to be motivated by the aspiration of the tribunal, but is going to be influenced by political pressures. And as long as that is the appearance, the United States is not going to join the court and will reserve its support for the court to those very rare cases where there is Security Council consensus that an incident should be submitted to the tribunal for investigation. So I don't see us joining anytime soon.
Okay, Professor Cohen. Same question.
Regarding the U.S.?
Or the Israel. Same spec.
I am not, I don't have the competence, I
the
think,
big
to
devil and the little.
answer regarding the U.S., but I'll say something about Israel. I think Professor Kantorovich was correct in emphasizing the issue of the settlements. There are claims of violations against Israelis in the operations in Gaza, but these are first investigated. And second, when you look around, you see that these are actually not of the gravity that even if they are correct, I don't think they are correct, but even if they are correct, they are not of the gravity that the International Criminal Court usually looks into. However, there is one issue in which Israel refuses to accept a position on principled ground, and it's the question of the settlements. And here, the issue cannot be a question of complementarity, because Israel, by definition, will not investigate this on principled grounds. It does not accept that this is even a violation. And because it's an issue that's in international politics receives a lot of attention, it might garner the attention of the prosecutor, claiming that this is a grave enough issue. So Professor Kantorovich was correct, I think, in suggesting that if we should worry about anything, it should be about the issues of the settlements. I think this is the implication of what he was saying, and then he was suggesting that there are countermeasures Israel could use, and regarding Cyprus and Morocco, that other countries have this question too. But this has always been the major impediment of Israel joining, because other than that, I don't think that it is such a sharp sword above Israel. Of course, Israel will never join before the U.S. As long as we have the U.S. not joining, the Israeli policy is okay. It actually, if you know the history of joining the ICC, Israel has signed the ICC, but because the U.S. withdrew its signature, Israel withdrew its signature too. I think it was immediately afterwards in terms of minutes. As a policy matter, the question, of course, is what will happen if there will be some surge in joining the ICC in countries like, say, for example, the U.S. will join for some reason, political reason, perhaps in order to garner international support for a specific operation. There might be a situation. What will Israel do then? This is the complicated question.
Okay, I would like to ask each of you the same question. Many of your colleagues feel that the ICC prosecutor has until now acted with restraint when it came to Israel, for instance, with the Mavi Marmara case some 5 years ago already, although it has ability to initiate and she had a jurisdiction. Is world political reality a sufficient check on the prosecutor's power and ambition?
I actually think it's the exact opposite. Again, I think there's a concern if you're the ICC prosecutor, that you're perceived as equitable in terms of who you're targeting, right? So if you look at the ICC to date, the target has been principally Africa. So you need something to counterbalance Africa, right? Where are you going to look? You're going to go after the U.S. or you're going to go after Israel? What's a more? I recognize there's an element of cynicism here. But if we had General Gotovina up here, he would tell you that's why he ended up there. Because the ICTY prosecutor went after principally Serbians and or Bosnian Serbs. They needed something to counterbalance that. They needed a high-level Croatian defendant. And he was the appealing target. So I think that the perception that an international tribunal has to be equitable in its assertions of jurisdiction will actually undermine an evidence-based, credibility-based assessment of who the targets of prosecution will be, which I think ultimately undermines the credibility of the tribunal, but those are, in my eyes, not necessarily in the eyes of the broader international community.
Yeah, I would dispute the premises. Not bringing proceedings, not opening criminal inquiries in cases where there's no jurisdiction and that are clearly meritless is not an exercise of restraint. It's just kind of normal. And indeed, I never understood the point of the Marmara cases, given that they were barred not only by complementarity and not only by gravity, really for 1,000 reasons. They were such marginal and difficult cases. I never understood why anyone took the opportunity of bringing them. I mean, on the complementarity issue alone, forget Israel, Turkey is investigating this, and nobody thinks that Turkey is engaged in pretextual, in absentia prosecutions of IDF officers. So maybe these cases were even brought so that they could be easily dismissed, and the prosecutor could say, look, I don't go after Israel for everything. But I think there has not been much evidence of restraint. And indeed, I think international political pressures in a very perverse way might encourage the prosecutor proceeding against Israeli officials where otherwise she shouldn't, because look what the prosecutor has faced so far. She went after the dictator of Sudan, Bashir, for genocide, a case referred by the Security Council. This is the most important crime for the ICC to proceed with, the crime of the greatest gravity. She couldn't make a case because Sudan wouldn't cooperate, and the international community does not have the interest to stand up to Bashir. She went after the head of state and deputy head of state of Kenya for election violence. This is a case that the prosecution took upon themselves. That case completely collapsed. So what the prosecutor is probably noticing is when you go up against non-democratic countries that are doing very, very bad things, it's going to be hard because they're not going to play ball, and then you'll be wasting your time. So maybe if you go after democratic countries, then it might actually work out better. So in a sense, there's a perverse incentive not to go after the genocide in Sudan, where the ICC will be powerless, but to go after otherwise low-hanging fruit that, on the other hand, will not greatly advance international justice.
Okay.
Okay. Very briefly, I think this brings us back to what you asked me. The question is, do you do anything in order to please the world? You know, because you went after, let's say, for reason or for no reason, of course for reason, for certain countries, but they were not only Africans. There are other cases also, I think, British soldiers and the US soldiers, but okay, so you went after them. Now you have to balance it. This is the way prosecutors should think. I'm sure that not, and I hope that not. As I told you earlier, we are definitely not against the ICC or not against the prosecutor. We have no reason to do it. On the contrary, but still, the question if, on objective grounds, is there any reason to do anything? If you're talking about the flotilla incident, of course, there is no gravity. We understand it. But the question is, why didn't you go about other things? Is there any case in the world that, okay, there are casualties, about, I think, 8, if I'm not mistaken, and 50 wounded, but is there any other cases that there are 4 committees, including 2 international committees, Palmer Committee, the committee by the HRC, the Turkish Committee, and the Turkish Committee, and the proceedings in Turkey. It's quite surprising that this was not the reason to not do it in the first place. Hopefully things will go to a good place. We try to do our utmost that things will be settled the way they should.
Okay, we have a few minutes for questions from the audience, but I would like to ask you to avoid questions we define at the Knesset as "isn't it" questions.
Could I just make one comment I think is important? I mean, the whole discussion has been relatively, if you think, it's pretty negative, you know, the prognosis. I think one of the things we should keep in mind, and I know that this is something that's very close to the mentality of the Military Advocate General's office, is that if you look at what we can control and what we can't control, there's a lot we cannot control. One thing we can control is the genuine credibility of our own investigations and our own disciplinary process. At least if we do that, if we're ever confronted, then we are going to be more credible when we say this is an illegitimate assertion of jurisdiction. And so I compliment the efforts of the IDF, the Military Advocate General's Corps, and the commanders out there who are committed to the standard that is expected under the law to hold your own people accountable for misconduct and to do credible investigations. And it is the best thing that the IDF or the U.S. military or any military can do if they want to guard against an unjustified assertion of jurisdiction by an international tribunal.
Okay.
Our first question goes to the Jerusalem Post.
This question is for Secretary Mandelblit. Good to see you. You talked briefly about the Turkel Commission. If we want to talk about things that Israel could do to prevent ICC intervention, there are the 18 recommendations of the Turkel Commission. Israel has implemented many of them. Two I want to ask you about, which I think even some sources, I will say, who are connected with the Turkel Commission are not thrilled about so far to date. One is recommendation 10 was to put a hard timeline on how long the IDF could take to indict for war crimes. There are obvious reasons why one would want some wiggle room on that. Ehud Olmert might have a third indictment against him, but the prosecution has been holding out on it for tactical reasons. But one could say 1 year, 2 years, 3 years with wiggle room. What more can be done in terms of implementing that recommendation? The second recommendation is the independence of the Patzar, the MAG. Only 2 weeks ago, the Justice Ministry came out with something to increase the independence of the MAG, but in the meantime, constantly since September, certain IDF commanders have been coming out in the press, putting out certain pressures on the MAG not to criminally investigate certain things. What more can be done to clear up the independence on that issue?
Okay, I think first of all, I think that the second part of the Turkel Commission, which you related to earlier, I related to the first one. I think it's very important. The reason it was established is because we are certain what Jeff Corner said, that we do deal with ourselves the way we should. And I told it before, it's not because of them, it's because of us. Now, we are ready that everybody will inspect it. And I think that Justice McGowan Davis, after the Thomas-Schott Commission, which was held after the Goldstone Commission, has clearly put out that the Turkel Commission is very important, and I think it has high credibility. And I think that it's very important that what was, although the Commission said that our system works according to international standards, and it's okay the way it is. Still, it has several recommendations, and I think we try to follow them to the extent that we can. Now, concerning the time limit, I told you before, I talk about my time. I have slight idea of what is taking on today. And I think it's the same. The MEG Corps do try to do their utmost to make it as fast as possible. But it was also held in the Thomas-Schott Commission that you must understand that dealing with investigations concerning operational occasions or operational issues is much more complicated than any other place. It's not going here in Jerusalem, someone was stabbed, okay, you take the knife, you take DNA. It doesn't work this way. You have to find who was shooting. So a woman was shot in the middle of Gaza. Now, who shot the fire or the bomb or the cannonball? You have to try to find first of all the unit, then you have to try to find the commander, the soldier, and so on. And mostly, I'm talking about what has happened in Kesed operation, what is happening now. We do succeed to come to the unit, we do succeed to understand what has happened, but it takes time. Nobody does it on purpose. On the contrary, we have all the reason in the world to do it as fast as possible. First of all, because we want to know the truth, we want to know what happens. Most of the time, when you come to the truth, you have good explanation. The worst thing is that a civilian was killed and you don't have an explanation. This is the worst thing. It's not good for us not to find explanation. We do try to find explanation because it will be the best thing. Most of the time, the explanation will be that everything that the soldier did was okay. But in those cases that you find that they act not according to the rules or to the laws, then measures will be taken against them.
So you don't think
it's our
you
interest.
think we shouldn't set a maximum time?
Excuse me?
You think we should not set a maximum time?
We should not?
Do you think a maximum time should be set?
No, I don't think so. I think it might be a mistake. There might be a timeline that you put, hopefully to go and conclude the investigation. But, as I told you before, no soldier, no commander should pay a price for a reckless investigation. Because at the end of the day, you want to find the truth. And as long as it will take, it will take. Even in civilian cases, there are cases that take years to investigate. So there might be guidelines, okay? But there's no way that you say, okay, you have 6 months to finish the investigation no matter what. Doesn't work this way. And I think also lately, there was a BOI, Board of Inquiry, of the General Assembly, Secretary Ban Ki-moon. And I think there were several cases there that went to criminal investigations, and they understood that it might take time. That is why they gave the recommendations that there is a report. Most of it is confidential, but they did understand that this investigation in such an environment takes time. So you don't make any soldier or any commander pay a price for negligence because someone is rushing us. You have to stick to the truth. Okay. Now, the last thing, will be very short. You asked about another recommendation, right? There was another. Okay, there's no question. The MEG is independent. He was independent. He is independent, and he will be independent. And I think the last things that were held, by the way, it is accepted by the commanders, it is accepted by the political echelon. Everyone understands it, that the one who is in charge of the rule of law must be independent, and this was not because of the ICC or any committee. This is a long time way that all the MEGs were brought on from the time of Meir Shamgar and even earlier, okay, in 67. So there's no question about it.
We only have a few more minutes, so I'm going to ask the question makers to limit their questions to very short, and also the panelists to give us short answers, okay? Not that that wasn't an exceptionally good answer.
I'd like to inject some heresy into the fundamental premise of this panel. Alan Dershowitz has said that the expectation, the thought that Israel could get a fair hearing before any international tribunal is the equivalent of expecting that a black man can get a fair hearing before a Mississippi jury in the 1920s. Maybe the black man had a better chance. Given the fact that, using the Mississippi jury as an example, you have the people who are judging it are inherently biased. why should we even bother with an international criminal court or the International Court of Justice? Most of the countries are not democratic countries in the world. Most of the people appointed will not be fair lawyers. Why bother?
Just to be clear, Israel and the United States is not bothering with the ICC. Both of them have not bothered to join. That's the situation. That doesn't mean the ICC can't bother them, potentially.
Well, can I just very quickly? I mean, you really have two choices. It's an international institution that has been created and is viewed by the rest of the world as credible. You can completely disengage from it, and then you have no influence on its evolution, or you can try and influence it from the periphery, which is what both Israel and the United States have done. They continue to do, and I think it's a wise policy because it's going to be there, and it's going to put people at risk in the future. And if you have no influence on it, you're worse than if you have some influence on it, even if you recognize it's got inherent flaws that prevent you from joining it.
This one question is directed to Professor Korn. I'll hold it, sorry. So you brought up a concept in this context of the discussion about how effects-based judgment is not appropriate. And you spoke of a case that you were involved in where a soldier was tried by a civilian judge and jury. And it was mentioned many times that the battlefield isn't black and white. And, it's hard for a civilian judge or a civilian court to really know, what goes down. Was what happened justified? So to clarify, first, how would you know that having a military, personnel proceed, a military proceeding, wouldn't be biased? And two, do you believe that the ICC should only have military personnel or judges, or if they have a jury, have military experience?
No, I don't believe that it has to be all military. In my opinion, ideally, we would have a mixed panel of civilian jurists and military experts. And by the way, I don't necessarily believe that a military advocate, a military lawyer, is the right person. I think that having someone like Colonel Kemp involved in a tribunal like that would add credibility to cases involving complex battlefield judgments. I will tell you that the complicating issue here goes back to what Penina said this morning. In issues related to what is a target, what is proportional, when should you do a precautionary warning, the key question is the word reasonable. And reasonable is contextually based objective assessment. So the question is, what would a reasonable commander have done under the same or similar circumstances? And the thing that stunned me when I was a witness in that case was that the prosecutor had his opinion of what reasonable was, the defense had their opinion of what reasonable was, the judges had their opinions of what reasonable was, I had my opinion of what reasonable was, and none of them were close. So the ultimate issue is, if we're going to hold military commanders to a standard, then that standard has to be understood. Another option might be that the tribunal would appoint its own experts, commissioners. So when a federal judge in the United States does a railroad case, the judge appoints a commissioner to help him understand the complexities of railroad operations. Why couldn't the court do something like that? My fear is that there's this assumption, it's bizarre, that if you allow the military to be involved in military adjudications, it's somehow invalid. And that seems completely backwards to me.
Thank you. Okay, I think we only have time for one more question, and we invited these people because they're brilliant. So no introductions necessary. Just ask the question.
I have heard the term international community, international law, all of this meaning what? What is international law? Who determines international law? And who is the international community? Is it the nation of Rwanda, Congo, or is it Russia, the United States? What makes people understand and accept? Is it the power of the great countries versus the power of the little countries? How are we to determine?
Let me give it a shot. Let me give it a shot. It depends. If you're a defendant in front of the International Criminal Tribunal for the former Yugoslavia, international criminal law is what the 3 judges say it is. If you are a state seeking some measure, some remedy in front of the International Court of Justice, international law is what the international judges say it is. Now, it's not completely arbitrary, which I think is the suggestion of your question. It's supposed to be based on the consensus of members of the community, which are the states themselves. As Panina said this morning, states make international law, and there's uncertainty there. But the more credible it is, the more consistent it is with widespread expectations, the more legitimate it is. As it diverges from that, the legitimacy tapers off, and it undermines the credibility of the system writ large.
One more quick question. Very quick.
Okay, when we're talking about the jurisdiction of the ICC, we've established that the U.S. and Israel are not party to that because they have not ratified the statute. So we've established that they don't have jurisdiction over Israeli and American citizens. However, is there a concern, for example, for an IDF soldier who has dual citizenship, say Israeli citizenship and French citizenship at the court, when he was acting in his capacity as an IDF soldier? Is there any legitimate concern for that, for being tried in the court?
So the dual citizenship, pure citizenship basis, theories have so far been rejected by the ICC. There was a campaign, an idea that the ICC should open an investigation into the situation in Syria on the basis that many of the combatants there, in particular those from Europe, were citizens of ICC member states, and that was thought to be too diffuse a basis. But of course, the principal thrust of the current problem is that the ICC may say that they are committing acts on the territory of Palestine, which the ICC wants to say is a state. And that is the principal thrust of the current concern.
Okay. So thank you very much, professors, Major General. Thank you. And I was asked to say that Mincha will be here to the left.